We're back in session. The jury is absent. We're going to have a preliminary charge conference now, based on the evidence that has already been presented in the case. I'm going to give you a little bit of a rough draft on how I believe that the court would be compelled to instruct the jury. I've made 4 copies. Give the DA 2 and 3 and 2 to the. Y'all have to share at some point. Decide who you're going to share with. Let me just, in a general way, these don't give you the numbers, but let me give you the numbers. Specifically, I'm going to instruct under our pattern jury instruction on the function of the jury under 101.05. Defining the burden of proof and reasonable doubt under 101.10, how the jury is to view the credibility of witnesses under 101.15, and the weight to be given any evidence under 101.20. I'll give an instruction on circumstantial evidence under 104.05. I'll give an instruction on interested witnesses under 104.20. Depending upon the what the future evidence shows, I may have to give some other instructions with regard to witness testimony, but at this point, that's all that it looks like I'm going to need to give. I'll give an instruction under 104.94 on the testimony of expert witness and how the jury is to look at and view that. And then I'm going to give the instruction on the elements of murder in the first degree. I'm actually using the 206.11 instruction, but that instruction deals with first-degree murder where no deadly weapon is used, but it also includes a number of lesser included offenses that are not appropriate here, as well as self-defense. So I've gone through and stricken everything from that instruction except the definition of murder in the first degree, the definition of murder in the second degree, and also I've given an instruction on acting in concert under let's get the number here. Under 202.10 and tailoring it into that instruction. Y'all know it's a standard instruction on first and second degree murder with acting in concert. So the option is for the jury to look first at first degree murder, and failing that, second degree murder, and failing that, not guilty. And then I will address the additional charge of accessory after the fact to first degree murder. And the form to be used is 202.40, although that's just a form, and I've had to tailor it significantly to the facts of this case. But as you can tell, the option is guilty of accessory after the fact to first degree murder, or guilty of accessory after the fact to second degree murder, not guilty. The elements of the offense of accessory after the fact are that that another person committed the crime of murder of Laura Ackerson, that the defendant knew that that crime had been committed, and the defendant knowingly aided and assisted Grant Hayes, in this case, to attempt to escape detection, arrest, and punishment by engaging in acts, in this case, specifically disposing of parts of Laura Ackerson's dismembered body. To assist him in the commission of that crime. And so those are the elements as set forth in the pattern instruction. Obviously, to be guilty of accessory after the fact of first-degree murder, the state has to prove the defendant knew that Grant Hayes had committed first-degree murder. To be guilty of accessory after the fact of second-degree murder, then the state has to prove beyond a reasonable doubt that the defendant knew that Grant Hayes had committed what in law would be second-degree murder. That is, that the state would have to prove that the defendant knew that Grant Hayes had intentionally wounded Laura Ackerson with malice, and that act proximately caused Laura Ackerson's death in order to be guilty of any crime of accessory after the fact. The counsel had suggested earlier that that they would rely in part upon some theory of accident. Do you still contend that?
We do, Your Honor.
Okay. Well, the accident instruction is under 307.10. The defendant's counsel had previously contended that the defendant acted under duress. Do you still contend that?
I do, Your Honor.
And that instruction is under 310.10. And I have kind of woven those two instructions under the facts of this case in the charge on accessory after the fact of murder. So let me just read it. Let's just read through it so you can all kind of get some feel for how I've done this. Because I think the homicide charge is relatively simple and it's straightforward and it's consistent with the way we always charge on homicide by acting in concert. But accessory after the fact, given the unique evidence in this case, requires a little more specific explanation. So let's read through what I've got here. The defendant has also been charged with being an accessory after the fact to the first-degree murder of Laura Ackerson. By her plea of not guilty, the defendant has denied each and every element of that alleged crime. The defendant, by her testimony, denies that she killed Laura Ackerson and denies that she knew that Laura Ackerson was dead until after the defendant arrived in Texas with Grant Hayes. The defendant contends that any act she committed in Texas which may have assisted Grant Hayes in disposing of parts of Laura Ackerson's dismembered body was committed by her only because of coercion and duress by Grant Hayes. By this testimony, the defendant has raised the defense of coercion and duress. Under the law of the state, the defense of coercion and duress is permitted to excuse criminal acts as involuntary, but only under circumstances in which a person reasonably believes that they must commit those unlawful acts in order to avoid suffering immediate death or serious bodily injury to themselves or to some other person. The burden of proof that the defendant acted only because of duress and coercion to save herself or another from immediate death or serious bodily injury is upon the defendant. It need not be proved beyond a reasonable doubt by her, but only to your satisfaction. The defendant would not be guilty of the crime of accessory after the fact of murder if her actions were caused by a reasonable belief that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute the crime charged. The defendant's assertion of coercion and duress is a denial that she voluntarily committed any crime. the burden remains on the state to prove the defendant's guilt beyond a reasonable doubt. For you to find the defendant guilty as an accessory after the fact of first-degree murder, the state must prove two things beyond a reasonable doubt. First, that first-degree murder of Laura Atkinson, as I have defined that crime to you previously, was committed by some person other than the defendant, specifically Grant Hayes. And second, that after that crime was committed by Grant Hayes, the defendant, knowing that Grant Hayes had committed first-degree murder of Laura Atkinson, willfully, knowingly, and intentionally assisted Grant Hayes to attempt to escape detection, arrest, and punishment by helping Grant Hayes dispose of dismembered parts of the body of Laura Atkinson. The defendant has testified that Grant Hayes described to her the death of Laura Atkinson, have described to her that the death of Laura Atkinson was accidental. She denies that she knew that Laura Atkinson had been murdered by Grant Hayes. A killing is accidental if it is unintentional and occurs during the course of lawful conduct. A killing cannot be intentional or premeditated if it was the result of an accident. When the defendant asserts that the alleged victim's death was an accident or that the defendant reasonably believed it to be an accident, these are assertions denying the existence of those facts which the state must prove beyond a reasonable doubt. The burden is on the state to prove those essential facts, and in so doing, disprove the defendant's assertion of accidental death or lack of knowledge of an intentional killing. The state must satisfy you beyond a reasonable doubt that the victim's death was not accidental and that the defendant knew that the death was not accidental before you may return a verdict of guilty of any criminal charge. So I instruct you that if you find from the evidence beyond a reasonable doubt that on or about July 13th of 2011, another person, Grant Hayes, committed the first-degree murder of Laura Atkinson, specifically that Grant Hayes intentionally, with malice, after premeditation, and with deliberation, killed Laura Atkinson by acts of violent trauma to her body that proximately caused Laura Atkinson's death, and that the defendant knew that Grant Hayes had committed the first-degree murder of Laura Atkinson, and that the defendant did thereafter knowingly, willfully, and intentionally assist Grant Hayes in attempting to escape detection, arrest, and punishment by helping Grant Hayes dispose of dismembered parts of the body of Laura Atkinson, then it would be your duty to return a verdict of guilty of accessory after the fact of first-degree murder. However, if you do not so find or have a reasonable doubt as to one or more of these things, you would not find the defendant guilty of that crime. You would also not find the defendant guilty of that crime if the defendant has satisfied you that she reasonably believed that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute this crime. If you do not find the defendant guilty of accessory after the fact of first-degree murder, you must determine whether or not she is guilty of accessory after the fact of second-degree murder. You will recall my previous definition of second-degree murder. If the state fails to prove beyond a reasonable doubt that Grant Hayes committed first-degree murder of Laura Atkinson, or even if the state has proven that Grant Hayes committed all of the elements of that crime beyond a reasonable doubt, but has failed to prove beyond a reasonable doubt that the defendant knew that Grant Hayes had committed first-degree murder of Laura Atkinson, the defendant could be guilty of no crime greater than accessory after the fact of second-degree murder if the state proves that Grant Hayes committed murder by intentionally inflicting violent trauma to the victim with malice, proximately causing the victim's death, and the defendant thereafter, knowing that, did knowingly, intentionally, and willfully assist Grant Hayes to attempt to escape detection, arrest, and punishment by voluntarily helping him dispose of dismembered parts of the body of Laura Atkinson. For you to find the defendant guilty of accessory after the fact of second-degree murder, the state must prove beyond a reasonable doubt that Grant Hayes intentionally and with malice inflicted violent acts of trauma to the body of Laura Atkinson that proximately caused Laura Atkinson's death, and that the defendant knew that Grant Hayes had inflicted violent acts of trauma to the body of Laura Atkinson with malice, which proximately caused her death, and the defendant, with that knowledge, did knowingly and intentionally and willfully assist Grant Hayes to attempt to escape detection, arrest, and punishment by voluntarily helping him dispose of dismembered parts of the body of Laura Atkinson. So I instruct you that if you find from the evidence beyond a reasonable doubt that Grant Hayes intentionally and with malice inflicted violent acts of trauma to the body of Laura Atkinson, thereby approximately causing her death on or about July 13th of 2011, and that thereafter the defendant knew that Grant Hayes had intentionally and with malice inflicted violent acts of trauma to the body of Laura Atkinson, thereby approximately causing her death, and that the defendant with that knowledge did thereafter knowingly, intentionally, and willfully assist Grant Hayes to attempt to escape detection, arrest, and punishment by helping him dispose of dismembered parts of the body of Laura Atkinson, then it would be your duty to return a verdict of guilty of accessory after the fact of second-degree murder. However, if you fail to so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty to any criminal charge. It would also be your duty to return a verdict of not guilty if the defendant has satisfied you that she reasonably believed that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute this crime. And then I've given the final instructions, let's see, under 101.35, and the verdict sheet will be let's see if I have a copy of it here somewhere. I haven't prepared a verdict sheet, but obviously the verdict sheet will be one with a special verdict form. The option will be, we, the jury, return as a unanimous verdict. The defendant is guilty of murder in the first degree, or guilty of murder in the second degree, or not guilty. On the first issue, the jury verdict sheet will say if you have answered one, the first issue, guilty of murder, you will not answer the second issue. If you've answered issue number one, not guilty, then answer the second issue. And then the second issue will be, we, the jury, return as our unanimous verdict. The defendant is, one, guilty of accessory after the fact of first-degree murder, or guilty of accessory after the fact of second-degree murder, or not guilty. Also, I think I've included one last paragraph that I did omit reading. I've explained that to the jury before I got to accessory after the fact instruction. The last paragraph before we get there, I tell the jury, if you have returned a verdict of not guilty to the charge of murder, you must then determine whether or not the defendant is guilty of accessory after the fact of murder committed by another person. If you have returned a verdict of guilty to either first-degree murder or second-degree murder, you will stop and will not address the charge of accessory after the fact. Under the law of the state, a defendant cannot be guilty of a murder and guilty as an accessory after the fact to that same murder. I'm not particularly content with the language of the accessory after instruction as being simple and simplistic, because it's not. The problem with the way in which to instruct the jury is a little different in this case, is because of the defense of coercion and duress, which the defendant has the burden on. And if I turn that around and impose an element of voluntariness on the part of the state, I have shifted the burden to the state to disprove that beyond a reasonable doubt. And the law does not require that. So you'll make sure that you make note of the fact that in my final mandate, although I make reference to what would constitute accessory after the fact to murder, and I make reference to the fact that it would involve a determination that the defendant acted voluntarily, my final mandate clearly shows that the state has the burden of only proving the elements that I've listed, and the defendant has the burden of proving that she acted under duress and coercion under circumstances in which a reasonable person would believe that they were in danger of immediate death, or they or another person would be in danger of immediate death or serious bodily injury if those acts were not committed. If somebody can think of a better way to present it, I'll be glad to hear your written request the next time we meet. That's why I've given all this to you now, and you'll have time to ponder it. I believe that I have at least honored the defendant's contention with regard to accident, because it appears to me that the contention of accident deals with both the homicide charge as well as lack of knowledge on her part that a homicide had occurred. And the way in which that's framed in this pattern instruction appears to me to satisfy all those requirements on the claim of accident. And I've simply followed the instruction on duress, the pattern instruction on duress and coercion. The defendant may have engaged in some other acts that might constitute disposing of evidence. But it appears to me that those acts, I'm concerned about the fact that those acts really are acts that sort of dispose or aim to dispose of the cover-up, or as opposed to the crime itself. So there's no question that if the jury believes that she knowingly assisted in disposing of the body, that is, and there is, in the light most favorable to the state, significant evidence of that, then that clearly is evidence that would support a conviction of accessory after the fact to murder, either in the first degree or second degree. I do not know that simply moving acid from one place to another place would be sufficient in evidence itself to support a contention that that act alone would constitute accessory after the fact to murder in the first degree or second degree. And I'll be glad to hear an argument about that. But if I give the jury that option, we won't know which option they take. And y'all may have an opportunity to try this case again sometime in the event she's convicted of anything. Frankly, it appears to me that if the jury believes the state's evidence, then it's pretty simple. If the jury doesn't, it's pretty simple. I don't see any need in complicating it. But that's where we are. I'll invite your additional written request or objections or further requests for modification the next time we meet. Anything else today?
Just, Your Honor, very briefly, just in the way of thinking about what will be presented to you in writing. We weren't prepared to do this today. But I believe that the law requires that you instruct the jury that they can convict her of either one of the levels of homicide or one of the levels of accessory, but they cannot convict her of both.
And that's in there.
Did I miss that?
Yes.
It's either one or the other.
Yes, sir. They never get to the accessory unless they found her not guilty of the homicide. Okay, and if they find her not guilty of the homicide, then they will address the issue of the accessory. Yes, sir. And I clearly indicated, let's see about, I think at the 1, 2, 3, 4th page where I say, under the law of the state, a defendant cannot be guilty of a murder and guilty as accessory after the fact of that same murder. Okay. All right.
I didn't catch that part.
Anything else?
The other thing I would ask that we be thinking about on that pertains to both the murder charge and the accessory is involuntary manslaughter. There's been evidence that this was an accident, according to the report that she made to her sister, that she had pushed her down and hurt her, and it was bad. And we would ask for an instruction on involuntary manslaughter as it pertains both to the murder charge and as it pertains to the accessory charge.
There is no evidence as to any injury on the body of the deceased that she well, there's no evidence other than a statement about a fall, which did not appear to be a fall of any significance that would cause a death sufficient to even concern your client that the victim was seriously injured or might have suffered a serious injury or cause her to believe that the victim may have died. From her description, she described a fall and then a struggle which she left. And you contend that the jury could speculate that after she left, something occurred that might constitute manslaughter or involuntary manslaughter?
I seem to recall Karen Berry saying something to the effect that one of the versions that she heard was that she had pushed her, that she had fallen, and that she was dead.
Well, Karen Berry doesn't have a clue what happened. She only had a clue what happened from what her sister told her. Her sister has not said anything in this courtroom that would suggest that Laura Ackerson died as a result of voluntary or involuntary manslaughter. Unless you can point me to it.
I think she indicated that she died as a result of an accident. An accident, I think, leads us to the issue of involuntary manslaughter.
Accident leads you to not guilty of any crime as accident is defined in law. Okay? So the request for an instruction on involuntary manslaughter or voluntary manslaughter is denied, either as to the homicide charge or accessory after the fact to any such charge. All right, that's where we are. Let's y'all stay in touch with one another, and as soon as we know when we can reconvene, we will reconvene. If you have specific objections to these instructions, I would ask that you put them in writing and you give me a better proposed instruction than the one that I presented you. And so I anticipate when we come back, we will move into the evidence, we'll finish the evidence, we'll have a final charge conference, and we'll be arguing this case. The defendant having offered evidence, the jury is going to be with the state to open and close. Do y'all anticipate you'll be doing both? Do you know? Disclosing? Do you anticipate right now you'll know whether you have one or two arguments? Two arguments. Okay. So the defendant will open, and how many y'all can figure out what you're going to do about your arguments. All right. Anything else? Okay. Sheriff will be in recess until further order of the court. Thank you.